I just want to give it a couple more seconds in case the stream chops off the first portion of this video. So, we have finally arrived at the time that I'm going to review the actual case files that pertain to me, and some of the evidence, some of the documentation that I have ready. So, firstly, let us review Judge Bryce Dyer's reasons in the matter of BCSC 64950-1, police file number 41017-8491. RV Evanshen. Mr. Evanshen is charged with 3 counts of information pertaining to 64950-1 as follows. He assaulted one Gavin Gambier on July the 25th of 2017. On the same date, he assaulted a police officer, one Constable McCarricker, with the intent to resist lawful arrest, and also the same day he uttered or conveyed a threat to Mr. Gambier to cause him death or bodily harm. He pleaded not guilty to all 3 counts. The Crown called 5 witnesses at the time of trial of this matter, and the accused also testified. In order for me to convict the accused of any of the charges he faces, I must find that the Crown has proven the essential ingredients of each charge beyond a reasonable doubt. There is no onus on the accused to prove his innocence. The decision of RVWD 1991 63 CCC 3D397 has application in this case. Therein, Corey J. of the Supreme Court of Canada commented on the application of reasonable doubt to the issue of credibility. In a case where credibility is important, the trial judge must instruct the jury that the rule of reasonable doubt applies to that issue. I would just mention, I don't think in the case where we have recorded video evidence surrounding the initial charge of assault that credibility is as big an issue as Judge Bryce Dyer seems to want it to be in his reasons. I would suggest that if we have videotape recording of the exact moments preceding and following the supposed assault, that is not so much an issue of credibility, it's more an issue of the accurate assessment of the evidence. The trial judge should instruct the jury that they need not firmly believe or disbelieve any of the witnesses or set of witnesses. Specifically, the trial judge is required to instruct the jury that they must acquit the accused in 2 situations. First, they believe the accused. Second, if they do not believe the accused's evidence but still have a reasonable doubt as to his guilt after considering the accused's evidence in the context of the evidence as a whole. See RV Chalice, 45 CCC 2D 546, Ontario Court of Appeal, approved in RV Morin, 1988, 44 CCC 3D 193 at page 207. So I find it interesting how the courts are very adverse to hearsay or conjecture, and yet it's formal court policy to implement a rule that surmises as to what a jury would do or could do. I don't think there's any individual trial judge that can actually know what a jury would do. I think that's, without question, conjecture. It's inappropriate to draw upon such description of formal court policy given the uncertainty that accompanies that exact description. Ideally, appropriate instructions on the issue of credibility should be given not only during the main charge, but on any recharge. A trial judge might well instruct the jury on the question of credibility along these lines. First, if you believe the evidence of the accused, obviously you must acquit. Secondly, if you do not believe the testimony of the accused, but you are left in reasonable doubt by it, you must acquit. Again, what a hypothetical jury would believe. seems inappropriate. Thirdly, even if you are not left in doubt of the evidence of the accused, you must ask yourself whether on the basis of the evidence which you do accept, you are convinced beyond a reasonable doubt that the evidence of guilt of the accused. In RVCWH 1991 68 CCC 3D 146 Wood JA, then of our British Columbia Court of Appeal, added one more ingredient to this test as follows. I would add one more instruction in such cases, which logically ought to be second in the order, namely, if after a careful consideration of all of the evidence you are unable to decide whom to believe, you must acquit. I will return to these principles below. And I would strongly argue that Gavin Gambier's credibility should be questioned. The judge automatically found Gavin Gambier, who I will tell you right now did commit perjury in his testimony. Gavin Gambier clearly committed blatant perjury in his testimony, but the judge found him more credible and me not credible. I will return to these principles below. I intend to summarize the evidence given by most of the various witnesses in this case. I am going to start by making reference to certain evidence the accused himself gave, some of which I find to be true and reliable. It is well understood that a trial judge may accept some of the evidence of a given witness, rejecting other evidence he has given. See RV REM 2008, Supreme Court of Canada 51, paragraph 65. He testified that on July the 25th of 2017, he had his girlfriend with him and took the bus with her at about 11 a.m., saw her off to work. He got off the bus at Park Royal Shopping Centre in West Vancouver and went into the Steve Nash Fitness Facility, he thought, in the early afternoon. He had joined this facility approximately 2 years earlier, I believe at the North Vancouver location. I joined the Steve Nash gym at the Granville Street location, and I still have some acquaintances that I did interact with a lot during my time spent there. I submitted numerous applications for employment to that location in the anticipation of their new Park Royal location, and just on a personal, very informal basis. Most of the reason I reacted so adversely to the actions of Gavin Gambier and the other employees there was that they were all occupying positions that I very well, given the applications that I submitted to the company in previous instances, could have been given myself. And I do feel as though I possess the skills and qualities necessary in order to do the jobs of the individuals that accused me. So that's a major factor in my emotional state, my reaction to all of the actions against me. But based upon his discretionary assessment, the judge chooses whether or not to acknowledge such hearsay as valid. He had met his girlfriend some 2 months earlier, and she had joined the West Vancouver Steve Nash gym approximately 2 weeks earlier than July the 25th of 2017. This is correct. I brought my ex-girlfriend Casey Sunmin Park into the gym with me. We started working out together at the Steve Nash gym on Granville Street. We enjoyed our time spent there together. I was really happy to see her doing a good job working out with me, and I was really happy. I was really happy at that point because fitness is very important to me, and to share that with somebody like my ex-girlfriend was very pleasing to me. So I had high hopes that everything would go smoothly. When I brought her into the gym, she met Mark Henriksen, the caller to police. She met Gavin Gambier. She met several other trainers. She signed a contract directly with Mark Henriksen, the caller to police. And he obtained, as well as the other gym staff members, the male gym staff members, obtained both of our personal information. And I think that's a significant fiduciary consideration. He then worked out twice, some downtime between each session. That's correct. So I patroned the gym early that day. I had my computers, which I carry with me all the time when I leave my house. I have my laptop computer and my iPads on me. I store it in a gym locker room, and then I work out for extended sessions doing strength training and cardiovascular and fat burn exercises, calisthenics, and then I will, upon a rest period, perhaps grab something to eat and devote myself to formal administrative and social communicative activities at my computer via a Wi-Fi connection or some form of internet connectivity. So late in the afternoon, I decided to acquire some beer. So after 2 extended workout sessions intermittently with sending out emails and communications via my computer, there is a large British Columbia liquor store that was brand new and opened immediately next to the Steve Nash Gym at the Park Royal. So upon entering the Steve Nash Gym doors, through the front doors, just to your right there's another large set of glass doors with a huge brand new opened British Columbia liquor store. The Steve Nash Gym has since closed at that location, as well as their other North Vancouver location, which is close, which I was patroning many years ago. And so I think it's interesting that the provincial government should convict me of alcohol consumption related actions, and that the provincial government in fact sold me the alcohol in question, the beer in question, as well as chose to open up a very highly marketed, brand new, aesthetically impressive liquor store in my immediate field of view and my immediate course of traversal between where I work out and where I would buy food. So I drank some beer on a hot summer's day, and Bryce Dyer considered that to be a seriously irresponsible action. But the liquor was sold to me by the provincial government itself, and it was highly marketed to me, and I don't understand how the provincial government can prosecute someone, and a strong portion of their argument for the culpability of that individual is that they drank the liquor that was sold to them and marketed to them. It's like, we're going to open up liquor stores, we're going to market alcohol to the public, but don't drink it. If you open up large liquor stores with impressive merchandising and make it all accessible to the public in their direct field of view and their direct field of travel, expect them to perhaps once in a while consume it. Late in the afternoon, he decided to acquire some beer and purchase a 6-pack of Filthy Dirty IPA with an alcohol content of 7% or 7.2 and consumed them all between approximately 6 p.m. and 7:30 p.m. When asked by the Crown Council if he was feeling the effects of the beer, he re-entered the gym at 7:30. He denied he was and said he intended to walk home. I did intend to walk home. As it states previously, I had taken the bus there, and that is a major factor as to why I did decide to consume a beer, is because I had no transportation of my own at that time, and so there was no chance of me ever driving home. I had access to public transit as well as Uber or taxi cabs at my disposal. I live in a 5-minute, no, more like a 10 or 15-minute walk from the location, and I intended to walk home. So from my perspective, consuming of alcohol in such context was not exceedingly a wrong decision. I do not accept, and I sarcastically remarked that I did not feel the beer, simply because I apologize for being sarcastic in such a serious legal context. I never should have said that, but after drinking 6 strong ales, the person asked me if I could feel the effects of it, and I said no. like sarcastically. I shouldn't have done that. I apologize for being smart alecky and sarcastic. I do not accept his own assessment as to his state of sobriety as true. He described himself then as a moderate, not heavy drinker, and estimated his average normal consumption was 8 or fewer beers a week. He agreed it was unusual for him to consume 6 at once, but said he reserved this level of consumption for sunny summer evenings. I do not accept the evidence as truthful. He then elected to return to the Steve Nash gym to retrieve his bag, which he had left in the locker change room. While standing in front of his locker in the facility, he had an interaction with 2 men, Mark Henriksen and Gavin Gambier, both managers at the gym. I turn now to the summary of Mr. Gambier's evidence. Mr. Henriksen did not testify at trial. Mr. Gambier was on July the 25th, 2017, the fitness manager at the Steve Nash gym and on duty during that day. I understand in the early evening hours. He had left the gym to buy coffee. He received a call from an employee, Sarah, who I can't remember having ever interacted with, to return to the gym, and so he did. He learned that the accused and a staff member or patron earlier had been involved in an incident giving rise to an internal report related to a serious threatening behavior on behalf of the accused, and that he had left the gym clearly frustrated and upset. So this is important to consider, that I was acquitted of having ever threatened anyone, and yet my supposed comments or interaction with the staff were enough to give rise to an internal report. What I'm suggesting is that the social context provided by my patroning of that gym facility with all of these young strapping males viewing me and my girlfriend and obtaining all of our personal information in a fiduciary context would lend itself well to their strategically acting in such a way as to defame, attack my relationship, attack my person, given their strategical advantage. Ali Najafian Razavi was present in the gym locker room as I first entered. He's a rather tall man, and he said to me, "Do you want to fight?" I looked at him and I said, you know, "Do I want to fight you?" I suggest you get a weapon, pal. You know what I mean? Like, I suggest you get yourself a, weapon, bud. And because, he had never asked me if what my name was, if I wanted to grab a cup of coffee, if I maybe wanted to play some basketball with him. He stood there silent until the moment that he uttered the words, "Do you want to fight?" And that was my response to his proposal. And that is what gave rise to their incident report. So Ali Najafian Razavi threatened me by proposing a physical fight without ever having met me, shook my hand, or knowing my name. And then he filed an incident report because I responded to him by telling him that he should probably attain a weapon if he wants to fight me. I feel as though my commentary was essentially in self-defense against a large man who had proposed physical conflict, verbally. So whether or not I did that in the most eloquent and reserved, conservative way possible or not is not a factor. What is a factor is that it was only him and I in that gym locker room, and then later he filed his. He was not dressed in Steve Nash employee clothes at that point, and later on in the videotape he is. So. So I was not convicted of a threat. So any report to gym staff was based upon something that does not constitute unlawful threats and is greatly over-exaggerated, contorted, and does not support any culpability on my behalf. He learned that the accused and a staff member or patron earlier had been involved in an incident giving rise to an internal report, Exhibit 2, related to serious threatening behavior on part of the accused, and that he had left the gym clearly frustrated and upset. I didn't really leave the gym frustrated or upset. I only began to become frustrated and upset when I was confronted by Gavin Gambier and Mark Henriksen while in the locker room. While Mr. Gambier was meeting with certain other gym employees, he learned that the accused had returned and was in the changing room. Mr. Gambier elected to go and meet him there in company with 3 employees to act as witnesses. He estimated the time to be about 9 p.m. So the video evidence clearly depicts a group of people essentially trying to bully me. And that, I think, is they're trying to victimize me, they're trying to bully me, and I think being outnumbered as I was and caught off guard and in shock as to their actions, I behaved in an erratic way, but at the same time, I think all of my actions were proportional and justified, defending my character, defending myself in the face of false accusations. So, however, loudly I was screaming at them or advocating my own correctness in the argument, it's not a fair and just assessment of the evidence. I can't go on here. One second.
R.V. Evanshen page. 1. Mr. Evanshen is charged with 3 counts on information 64,950-1 as follows. 1. He assaulted one Gavin Gumby on July 25, 2017. 2. On the same date, he assaulted a police officer 1 Constable McKerricker with intent to resist lawful arrest and 1. 3. Also on the same date, he uttered or conveyed a threat to Mr. Gumby to cause him to death or bodily harm. Times 2. He plead not guilty to all 3 counts. 3. Crown called 5 witnesses at the trial of this matter and the accused also testified. 4. In order for me to convict the accused of any of the charges he faces, I must find that Crown has proven the essential ingredients of each charge beyond a reasonable doubt. There is no onus on the accused to prove his innocence. 5. The decision of R.V. W.D. 1991, 63 CCC, 3D, 397 has application in this case. Therein Corey J. of the SCC commented on the application of reasonable doubt to the issue of credibility. He said this: in a case where credibility is important, the trial judge must instruct the jury that the rule of reasonable doubt applies to that issue. The trial judge should instruct the jury that they need not firmly believe or disbelieve any witness or set of witnesses. Specifically, the trial judge is required to instruct the jury that they must acquit the accused in 2 situations. First, if they believe the accused. Second, if they do not believe the accused's evidence but still have a reasonable doubt as to his guilt after considering the accused's evidence in the context of the evidence as a whole. C.R. v. Chalice, 1979, 45 CCC, 2D, 546, on CA, approved in R. v. Morin, 1988, 44 CCC, 3D, 193, at p. 207. Ideally, appropriate instructions on the issue of credibility should be given, not only during the main charge, but on any recharge. A trial judge might well instruct the jury on the question of credibility along these lines. First, if you believe the evidence of the accused, obviously you must acquit. Secondly, if you do not believe the testimony of the accused but you are left in reasonable doubt by it, you must acquit. R.V. Evanshen page 2. Thirdly, even if you are not left in doubt by the evidence of the accused, you must ask yourself whether, on the basis of the evidence which you do accept, you are convinced beyond a reasonable doubt by that evidence of the guilt of the accused. 6. In R.V. CWH, 1991, 68 CCC, 3D, 146 would JA then of our BCCA added one more ingredient to this test as follows. I would add one more instruction in such cases, which logically ought to be second in the order, namely, if, after a careful consideration of all of the evidence, you are unable to decide whom to believe, you must acquit. 7. I will return to these principles below. 8. I intend to summarize the evidence given by most of the various witnesses in this case. I am going to start by making reference to certain evidence. The accused himself gave some of which I find to be true and reliable. It is well understood that a trial judge may accept some evidence of a given witness while rejecting other evidence he has given. Cr. v. Rem 2008 seconds 51 para. 65. 9. He testified that on July 25, 2017 he had his girlfriend with him and took the bus with her, and at about 11 o'clock am saw her off to work. He got off the bus at the Park Royal Shopping Centre I_N West Vancouver and went into the Steve Nash fitness facility he thought in the early afternoon. He had joined this facility approximately 2 years earlier, I believe, at the North Vancouver location. He had met his girlfriend some 2 months earlier, and she had joined the West Vancouver Steve Nash gym approximately 2 weeks earlier than July 25, 2017. 10. He then worked out twice with some downtime between each session. R.V. Evanshen, page 17. Mall exit door was a very small tap to Mr. Gumby's forehead and could therefore be de minimis, or not an event that should ordinarily result in a criminal conviction. However, the 2ND head but which occurred outside was an intentional act on the part of the accused, was more forceful and was hence an assault. 84. As to count 3, the alleged threat uttered or conveyed by the accused to Mr. Gumby at the Steve Nash gym, Crown submitted that the accused's initial conduct therein directed to Mr. Gumby amounted to a threat. In the training room, after the accused had been asked to leave the gym a number of times, while yelling or screaming "liars" 8 or 9 times, he turned and approached Gumby very closely, causing Gumby to step back and put his hands up in a defensive posture. He felt threatened. 85. As to Court 2, the alleged assault of Constable McCarricker said to be in the cause of resisting his lawful arrest, Crown submitted that the accused knew McCarricker, albeit in plain clothes, was a police officer. He was told he was under arrest and he strenuously resisted arrest. Further, the arrest without a warrant was lawful pursuant S. 495(1) A. CCC and the decision in R. v. Story, 1990, 1 SCR 241 at paragraph 17. In arresting the accused, Constable McCarricker was entitled to rely on a fellow officer's instructions as occurred here. Corey J., in delivering the decision of the Supreme Court in Story at paragraph 17, said this. 17. In summary, then the Criminal Code requires that an arresting officer must subjectively have reasonable and probable grounds on which to base the arrest. Those grounds must, in addition, be justifiable from an objective point of view. That is to say, a reasonable person placed in the position of the officer must be able to conclude that there were indeed reasonable and probable grounds for the arrest. On the other hand, the police need not demonstrate anything more than reasonable and probable. Specifically, they are not required to establish a prima facie case for conviction before making the arrest. R.V. Evanshen, page. The defense, 86, some of the points made by the accused either did not relate to the charges he faces or support a defense including my having a reasonable doubt that Crown had proven his guilt as to counts 1 to 3 to the above requisite standard. 87. He did however argue that what he said to Mr. Gumby was not a threat. As 18. Well, his resisting arrest by Constable McCarricker was in his own defense of his loss of liberty. I took this to mean he was of the view that his arrest was unlawful and involved times an excessive use of force. I note that the reason he said that he felt his arrest was unlawful was that a kinder, gentler way of detaining him, for example a telephone call to his home inviting him to come to the detachment, could have been used, and if used, he would have attended. 88. Mr. Gumby was not a credible witness. He targeted the accused in doing what he did to boost his ego, perhaps because he had a girlfriend and Mr. Gumby didn't. 89. Finally, he said none of his actions amounted to an assault. Credibility. 90. I turn now to a discussion of the relevant legal principles that apply to a trial judge's assessment of credibility of witnesses, all of which I have considered. One helpful decision on point is that of R. v. Parent, 2000 BCPC 11, a decision of Her Honor Judge and Routhwaite formally of this court, wherein she dealt with the credibility of witnesses generally and how a atrial judge can assess it at paragraphs 4 to 5 of her reasons, where she stated as follows. R. v. Evanshen, page 19. 4. In assessing credibility, courts have recognized a number of factors as helpful. 5. These include 1. The witness' ability to observe the events, record them in memory, recall and describe them accurately. 2. The external consistency of the evidence. Is the testimony consistent with other, independent evidence, which is accepted? 3. Its internal consistency. Does the witness evidence change during direct examination and cross-examination? 4. The existence of prior inconsistent statements or previous occasions on which the witness has been untruthful. 5. The sense of the evidence. When weighed with common sense, does it seem impossible or unlikely? Or does it make sense? 6. Motives to lie or mislead the court, bias, prejudice, or advantage. To consider the obvious possible motive of every accused person to avoid conviction would place an accused at an unfair disadvantage. As a result, I do not consider that possible motive when assessing an accused's testimony. 7. The attitude and demeanor of the witness. Are they evasive or forthcoming, belligerent, cooperative, defensive or neutral? In assessing demeanor, a judge should consider all possible explanations for the witness' attitude, and be sensitive to individual and cultural factors, which may affect demeanor. Because of the danger of misinterpreting demeanor, I would not rely on this factor alone. 91. In paragraph 9 of her reasons, Her Honor Judge Routhwaite used the term ring of truth as a different way of expressing the point in paragraph 5 above, the sense of the witness evidence. 92. On this same point, our British Columbia Court of Appeal in Farnia v. Chomey, 1952, 2 DLR 354 commented, albeit in the context of credibility in civil actions. 93. There is a lower and different burden of proof in such cases as compared to criminal cases, nonetheless Farnier often referred to as containing a guiding principle. R. v. Evanshen, page 20. For judges in assessing credibility in criminal cases. This well-known case from our Court of Appeal encourages trial judges not to rely too strongly on the demeanor of a witness or the fact that his or her evidence remains uncontradicted, but rather we should be concerned with whether the evidence of the witness is consistent with the probabilities affecting the case as a whole. 94. The test, if you will, is repeated at p. 4 of the Quick Law Report of the reasons as follows. 11. The credibility of interested witnesses, particularly in cases of conflict of evidence, cannot be gauged solely by the test of whether the personal demeanor of the particular witness carried conviction of the truth. The test must reasonably subject his story to an examination of its consistency with the probabilities that surround the currently existing conditions. In short, the real test of the truth of the story of a witness in such a case must be its harmony with the preponderance of times the probabilities which a practical and informed person would readily recognize as reasonable in that place and in those conditions. Only thus can a court satisfactorily appraise the testimony of quick-minded, experienced and confident witnesses, and of those shrewd persons adept in the half-lie and of long and successful experience in combining skillful exaggeration with partial suppression of the truth. Times, emphasis added, discussion. 95. I will first make findings as to credibility and then deal with each count in turn and whether or not it has been proven by Crown beyond a reasonable doubt. 96. Mr. Gumby was a central witness in this case. I found him to be a credible Times witness. He seemed to have a good recollection of the events of the evening of July 25, 2017, and I felt he gave his evidence before me in a fair and objective way. For example, when questioned by the accused as to whether or not in making his decision to ask him to leave the gym and revoke his membership, had he not relied on a second IR v. Evanshen, page 21. Hand account that he could not be sure of and answered yes. He readily agreed that he had first approached the accused in the change room based on what two other employees had told H_him being in essence accurate. Mr. Gumby's testimony was corroborated by the video evidence presented by the Crown. He denied that he had head-butted the accused and at all times said he acted in a self-defense. On viewing the video, he readily admitted that he had pushed the accused but otherwise felt he had not, in following the accused out of the gym, acted at any time aggressively towards him. In my view, Mr. Gumby's testimony was not contradicted or shown to be unreliable in cross-examination. Also note that unlike the accused, for example, there is no evidence that on the evening in question, he had been drinking or that his mental faculties were otherwise impaired. As well, I find that what he was doing throughout his dealings with the accused was wholly within his reasonable mandate as the gym manager dealing with a problem patron. 97. I find the three police officers were credible witnesses as well, namely Constables McKerracher, McLean and Sorg. They were not shaken in cross-examination. 98. I did not consider Mr. Sampson to be a particularly significant witness in this case. 99. Turning to the accused, unfortunately I did not find him to be a credible witness. 100. Very importantly, I find that he had a great deal to drink on the evening before any of the events referred to in counts 1 to 3 occurred. By his own evidence, he drank in 1.5 hours, very close to what he said was his usual beer consumption at the time in 1 week, and it was very strong ale as well, having he admitted an alcohol content of 7 to 7.2%, I assume alcohol by volume. R.V. Evanshen, page 22. 101. I find that this alcohol consumption would have materially affected and did affect his mental processes, behavior and conduct after 7:30 p.m. on July 25. I think this is very obvious, reflecting as I do in the multitude of biblical and unusual references he made during the evening both to Mr. Gumby and the police. The majority of his conduct and utterances on the evening in question, in my view, clearly show that he was operating while his rational processes were materially impaired by the earlier consumption in quick succession of 6 strong ales. 102. I found at times the accused at trial was either unresponsive to questions put to him or evasive in answering a question, for example whether after drinking 6 ales, did he feel the effects, to which he said no. At times his evidence made no sense and cannot withstand the test in the Farina case, for example his above answer that he didn't feel the effects of drinking 6 ales in 1.5 hours yet described himself as a moderate drinker. A further example is his explanation as to why he turned his body to face Mr. Gumby on his way out, either that he feared he would be punched in the back of the head or in self-defense. This evidence makes little sense to me. Surely the accused well understood at the time that he was then an unwelcome patron of the gym and was being escorted outside, nothing more. 103. There were a number of inconsistencies in Mr. Evanshen's direct evidence and in his cross-examination, not all on material points. One example in cross-examination was his denial he had head-butted Mr. Gumby in the mall, and later evidence that he didn't recall, he wasn't sure. A further example was Crown suggesting to him that he had not cross-examined Mr. Gumby on the suggestion that it was he, Gumby, as per the accused's own evidence, who had head-butted the accused, and he said variously. R.V. Evanshen, page 23. That he had at least asked him about applying pressure on his face, but then said when asked again that they couldn't recall. 104. Mr. Evanshen again in cross-examination gave evidence suggesting he had at least on July 25 a bias towards police. When asked why had he not remained at the gym to await the arrival of the police if he felt in essence that it was he who had been assaulted, he said they would choose to victimize him had he spoken with them, but yet he denied that the impending arrival of the police at the scene had anything to do with his decision to leave the mall and take the bus home. 105. In the result, I find that wherever the evidence given by the accused differs from that given by Mr. Gumby or the police officers, I prefer their evidence to that of the accused. 106. I find that on his departure from the Steve Nash gym on the evening of July 25, when the accused throughout was in my view manifesting strong symptoms of being impaired by the alcohol he had just consumed, that he twice had butted Mr. Gumby. On the second occasion more severely than on the first, which if standing alone would not in itself merit a criminal conviction. Thus the Crown has proven he assaulted Mr. Gumby beyond a reasonable doubt. When Mr. Gumby pushed him away, he was clearly acting in his own self-defense. 107. I find that when Mr. Evanshen twice head-butted Mr. Gumby, he was not acting in his own self-defense, and Crown has proven this beyond a reasonable doubt. 108. I find that the police attended at the Steve Nash gym and spoke to Mr. Gumby, who then gave them a statement and particulars of his assault by the accused, including R.V. Evanshen, page 24. Confirming his name and identity to them. I find that Constable McKerricker learned in a police dispatch, and I understood as well from Constable Griffith, a fellow officer, and between approximately 9:27 to 9:34 p.m. that Mr. Evanshen had threatened and assaulted someone at the gym and was thus arrestable for these two charges. 109. As a result, he attended on 17th Street essentially looking for him and located him thereon and eventually arrested him for these charges. I find that the test referred to in R.V. story at paragraph 17 is met and the arrest was lawful and made in accordance with S. 495(1)(a) of the Criminal Code of Canada. 11. I find that the accused knew at all material times that Constable McKerricker was a police officer, and that throughout the majority of Constable McKerricker's efforts to lawfully arrest him, the accused very actively resisted and assaulted McKerricker in the course of his performing his lawful duty. 111. Finally, I find that while the accused's actions in the training area when he was in time's essence being escorted out of the gym from the locker or change room were somewhat menacing, that they do not amount to a criminal event within S. 264.1 of the Criminal Code of Canada. Section 264.1 states, 264.1(1) Every one commits an offence who, in my manner, knowingly utters, conveys or causes any person to receive a threat, a. to cause death or bodily harm to any person, b. to bum, destroy or damage real or personal property, or c. to kill, poison or injure an animal or bird that is the property of any person. R.V. Evanshen, page 25. 11.2. The accused did not, according to the evidence, threaten to kill and cause the death of Mr. Gumby, notwithstanding his yelling or screaming, for the most part, that he was a liar. Nor do I find that he conveyed in his actions towards Mr. Gumby a threat to do bodily harm to him. This term is defined in the Criminal Code as follows. Bodily harm means any hurt or injury to a person that interferes with the health or comfort of the person and that is more than merely transient or trifling in nature. 113. In reaching the above findings of fact and conclusions, I have kept in mind the provisions of the R.V. WD decision referred to at the outset with respect to each charge. 114. As to counts 1 and 2, unless otherwise stated, I do not believe the accused. As well, I am not left with a reasonable doubt by the evidence of the accused or any other evidence in this case as to his guilt on these two counts. On the basis of the evidence, which I do accept as truthful, I am convinced beyond a reasonable doubt of his guilt on counts 1 and 2. 115. I find the accused guilty on counts 1 and 2 and I dismiss count 3. The Honorable DGEB, Dyer, British Columbia. Times. Juries. 91, 97. B. Conclusion, count 2. 98, 98. C. Appeal from sentence. Her Majesty the Queen. Respondent. And Luke Jared Evanshen. Appellant. Before the Honourable Madam Justice Wachuk. On appeal from Provincial Court of British Columbia, February 4, 2019, conviction, and April 25, 2019, sentence, R. v. Evanshen, North Vancouver docket number 649501. Reasons for judgment. The appellant appearing on his own behalf. L.J. Evanshen. Counsel for the respondent. M.L. Crisp. Place and dates of hearing. Vancouver, BC. July 8, 2020. Place and date of judgment. Vancouver, BC. October 30, 2020. Table of contents. Paragraph range. Introduction. 1, 10. 2, Law. 11, 19. A. Statutory basis for summary conviction appeals. 11, 12. B. Appeal from conviction. 13, 15. C. Sentence appeal. 16, 18. D. The assessment of credibility. 19, 19. 3. The reasons of the trial judge. 20, 42. A. Count 1, assault of Gavin Gumby. 21, 32. B. Count 2, assault of CST, McCarricker. 33, 42. 4. Issues. 43, 46. A. Appeal from assault convictions. 43, 46. V. Discussion. 47, 105. A. Assistance from the trial judge, trial fairness. 48, 52. B. Unreasonable verdict. 53, 98. 1. Count 1. 57, 74. A. Video evidence. 61, 63. B. The Crown's discretion whether to call a witness. 64, 73. C. Conclusion, Count 1. 74, 74. 2. Count 2. 75, 98. A. Injuries. 91, 97. B. Conclusion, Count 2. 98, 98. C. Appeal from sentence. 99, 105. 6. Conclusion. 106, 106. Introduction. 1. On this summary conviction appeal, Luke Jared Evanshen was charged with and convicted of assaulting Gavin Aman Gumby, Count 1, and assaulting Police Constable Michael McCarricker, Count 2. Counts 3, 4 and 5 were charges of uttering threats to cause death or bodily harm to 3 individuals. On Count 3 Mr. Evanshen was found not guilty, and Counts 4 and 5 were stayed. All of the relevant events occurred on July 25, 2017. Although Mr. Evanshen has now changed his name to Dominus Rex Maximus Marcus Aurelius Israel Benjamin Jacob Joseph, I will refer to him by his former name as stated on the information, #64950-1. 2. On June 1, 2018, in North Vancouver Provincial Court, the trial commenced before the Honourable Provincial Court Judge B. Dyer, the trial judge. The appellant represented himself. The trial continued on October 17 to 18, November 1, and December 7, 2018. 3. In oral reasons on February 4, 2019, the reasons, the trial judge found the appellant guilty of counts 1 and 2, and not guilty of count 3. Crown Counsel directed a stay of proceedings on counts 4 and 5. 4. On February 6, 2019, the appellant filed a notice of appeal against his conviction. 5. On April 25, 2019, the trial judge sentenced the appellant to a 30-month conditional discharge concurrent on counts 1 and 2. 6. On June 27, 2019, the appellant filed a notice of application for extension of time to appeal sentence. On September 25, 2019, this court granted the appellant an extension of time to file his notice of appeal from sentence. 7. On December 4, 2019, the appellant delivered to the Crown and the court the transcripts of proceedings required for his conviction and sentence appeals. 8. On January 27, 2020, the appellant's application to this court pursuant to S. 683(5)(e) of the Criminal Code, RSC 1985, C. 46, to stay the probation order to which he was sentenced was dismissed. 9. May 27, 2020 was scheduled for the hearing of both the conviction appeal and the sentence appeal. That hearing date was adjourned to July 8 due to the COVID-19 pandemic, and the appeal proceeded on that date. 10. For the reasons that follow, I would dismiss the appeals against both convictions and sentence. 2. Law. A. Statutory basis for summary conviction appeals. 11. The authority for a summary conviction appeal is S. 813 of the Criminal Code. That section states that a defendant may appeal from a conviction and against sentence. 12. Section 822 of the Criminal Code provides that some of the indictable appeal sections of the Code, namely SS 683 to 689 with the exception of SS 683, 3, and 686, 5, apply to summary conviction appeals. B. Appeal from conviction. 13. The test to be applied by an appellate court in determining whether a verdict is unreasonable or cannot be supported by evidence is whether the verdict is one that a properly instructed jury acting judicially could reasonably have rendered. R. V. Biniaris, 2000 SCC 15 at Paras. 36-37. The focus of the inquiry is whether there is any evidence to support the trial judge's findings based on the totality of evidence before him or her, and whether the verdict logically flows from those findings. R. V. Seal, 2012 BCCA 19 at Para. 25. 14. Under S. 686, 1, a, of the Criminal Code, the court may allow the appeal where it is of the opinion that I. The verdict should be set aside on the ground that it is unreasonable or cannot be supported by the evidence. 2. The judgment of the trial court should be set aside on the ground of a wrong decision on a question of law, or 3. On any ground there was a miscarriage of justice. 15. With respect to credibility assessments, which figure prominently in this case, a reviewing court cannot interfere with those assessments unless it is established that they cannot be supported on any reasonable view of the evidence. R. V. RP. 2012 SCC 22 at Para. 10. C. Sentence appeal. 16. Section 687, 1, of the Criminal Code states that on the hearing of an appeal against sentence the Court of Appeal may, unless the sentence is one fixed by law, consider the fitness of the sentence and, a, vary the sentence within the limits prescribed by law for the offense of which the accused was convicted, or, b, dismiss the appeal. 17. Deference is owed to the decision of a sentencing judge. Appellate intervention is only justified where, 1. The sentencing judge has committed an error in principle, failed to consider a relevant factor, or erroneously considered an aggravating or mitigating factor that had an impact on sentence, or, 2. The sentence is demonstrably unfit. R. V. Again, 2018 BCCA 133 at Paras. 54-55. 18. Different standards of review apply to different kinds of findings. In R. V. Bacon, 2020 BCCA 140, the Court of Appeal explained the various standards of review as follows. 40. On questions of fact and inferences of fact, a reviewing court must ask whether there is palpable and overriding error. Hussein v. Nicolaisen, 2002 SCC 33. Madam Justice Bennett explained this standard as it applies in the criminal law in R. V. Nuttall, 2018 BCCA 479. 269. To state it simply, a palpable and overriding error is an obvious error that erodes the result. 41. This same standard applies to findings of credibility. RV, Gagnon, 2006 SCC 17 at para. 10. That means that a finding of fact based on acceptance by the judge of a witness's testimony may only be interfered with if the trial judge made an error that, as noted by Justice Moldava in dissent in RV, La. 2019 SCC 34 at para. 206, is plainly seen, Hussein at para. 6, and is shown to have affected the result, HL at para. 55. 42. Questions of law, on the other hand, are reviewed on a standard of correctness. This standard applies to an absence of evidence to support a finding of fact because such an absence is not a question of fact but a question of law alone. Nuttall at para. 272. D. The assessment of credibility. 19. In cases where a trier of fact is presented with contradictory evidence, the trier of fact must assess the credibility of the witnesses and analyze or weigh the contradictory evidence with a view to determining whether the Crown has proven its case beyond a reasonable doubt. Under the well-established framework set out in R. v. DW, W.D. 1991 Can Lii 93, SCC, 1991, 1 SCR 742 at para. 11. The following principles apply to the assessment of credibility in the criminal context. First, if you believe the evidence of the accused, obviously you must acquit. Second, if you do not believe the testimony of the accused but you are left in reasonable doubt by it, you must acquit. Third, even if you are not left in doubt by the evidence of the accused, you must ask yourself whether, on the basis of the evidence which you do accept, you are convinced beyond a reasonable doubt by that evidence of the guilt of the accused. 3. The reasons of the trial judge. 20. Although the reasons deal with the evidence in a manner that is not linear, on a thorough review of the reasons the trial judge found the following facts and accepted the evidence as follows. A. Count 1, assault of Gavin Gumby. 21. On the afternoon of July 25, 2017, the appellant went to the Steve Nash Fitness facility in West Vancouver to exercise. Afterwards, he went to a nearby store and purchased a six-pack of Filthy Dirty IPA, with an alcohol content of either 7% or 7.2%, and consumed them all between approximately 6 p.m. and 7:30 p.m. After drinking the beer, the appellant returned to the gym to get his bag from the locker room. 22. Mr. Gumby was the fitness manager of the appellant's gym. When he was working that evening, he received information that the appellant had, earlier in the day, made threatening remarks and that the appellant had left the gym clearly frustrated and upset. When the appellant returned to the gym to get his bag, Mr. Gumby went to meet the appellant, in the company of 3 employees, and told him his membership was to be revoked. 23. The trial judge described Mr. Gumby's testimony about what happened next, including the 2 headbutts which founded the charge of assaulting count 1, at paras. 17 to 24 of the reasons. Mr. Gumby, again received no response but noted the accused was very fidgety and not making eye contact with him. The accused then left the change room with his gym bag with Mr. Gumby and his 3 employees following behind. In the training area outside the change room, suddenly the accused started yelling at Mr. Gumby, liars, 8 or 9 times and saying he did nothing with Mr. Gumby, each time asking in a relaxed but assertive tone that he please leave the gym. During his departure, the accused on a number of occasions facing Mr. Gumby both approached him to within a few feet and, assuming what Mr. Gumby described as a fighting stance, called him a liar. Gumby reacted by stepping backwards, not wanting the accused to feel threatened but feeling threatened himself. He again asked the accused to leave. No contact occurred at this point. The accused then turned and, still angry, continued to depart from the facility with Mr. Gumby and his 3 employees following. Just before leaving the gym, the accused turned and stepped towards Mr. Gumby one more time and again called him a liar. Gumby put his hands in a defensive-like posture and again asked him to leave in a more assertive tone of voice. The accused then walked into the mall hallway outside the Steve Nash gym with Mr. Gumby following. At this point, the accused stopped halfway down the hall between the Steve Nash gym and the exterior mall exit door. He was then being filmed both by a following gym member and a gym employee. At this point the accused turned and screaming words to the effect that he was God or would see him in God at Mr. Gumby, bumped or butted his forehead against Mr. Gumby's head. It was a small tap, not hard at all according to Mr. Gumby. Again Mr. Gumby put his hands up, stood back and asked the accused in an assertive manner not to touch him and to please leave Park Royal. The accused's response was to point his finger 1 inch from Mr. Gumby's nose while calling him a liar. Mr. Gumby said he then felt threatened by the accused and just wanted him out. At this point, one of his employees called the police. The accused then turned and walked to the exterior mall exit door, went out but then again, when just outside the door, turned towards Mr. Gumby who was following and ran at him and headbutted him a second time. He estimated the force of the blow to be 12 to 15 pounds, not very hard, but hard enough to get a reaction out of him. Mr. Gumby pushed him away and the accused then left, walking towards the bus stop. He said he wasn't injured by the accused and that throughout his dealings with him, he was motivated to have regard to the safety of gym members present this evening as well as his own. 24. The trial judge then referred to the evidence of the appellant. In brief, the appellant testified that Mr. Gumby was verbally and physically aggressive towards him and accosted him in the gym change room, falsely accusing him of earlier misconduct and banning him from the gym. The appellant said he felt very threatened by him. As he walked through the change room towards the exit, Mr. Gumby and Mr. Henriksen, the facility's assistant manager, blocked his way and inhibited his departure. The appellant walked through the men into the gym area and said words to the effect, "You're Satan." The appellant then testified that he walked out of the gym into the mall, followed by Mr. Gumby, Mr. Henriksen and several others. The appellant was yelling at them that they were liars or Satan, and referred to himself as God. He testified that when he was approximately 5 feet outside the exit doors, Mr. Gumby forcefully pushed him twice, both times causing him to stagger but not fall. The appellant then walked away towards the bus stop.